crime investigating agencies follow the procedure laid down under CRPC. They tend to call the accused and the witnesses as a part of their investigation. As and when they call the witnesses, they tend to issue notice under section 160 CRPC. Let us first see what is this section 160 CRPC says about. It says that a police officer has power to require the attendance of a witness. Okay? And any police officer making an investigation under the Criminal Procedure Code may by order in writing require the attendance before himself of any person being within the limits of his own or any adjoining station who from the information given or otherwise appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required, provided that no male person under the age of 15 years or woman shall be required to attend at any place other than the place in which such male person or woman resides. Though under section 160, when a notice is issued by the crime investigating agencies, though one needs to attend within the jurisdictional office of the crime investigating agency, but there is an exemption in this case with reference to the individuals below 15 years of age and also for women, and they need not attend for investigation at the crime investigating agencies offices. Rather, they can request the crime investigating agencies to come to their homes and investigate the matter, or even the crime investigating agencies and their concerned officers may tell them that if you intend so, we can come and investigate the matter at your home. So the relaxation is there for women and for persons under the age of 15 years. I mean to say persons below the age of 15 years. So apart from this, what we need to see here is the state government may by rules made in this behalf provide for the payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his residence. This is a beautiful clause in CRPC. Under this clause, even a witness, when he appears in the crime investigating agency's offices, then he will also be reimbursed at reasonable cost his commuting charges, and he will be more respectfully dealt with as a part of the investigation, and he will also be reimbursed with his travel costs. This is what is all about 160. So, section 160 CRPC is for obtaining the statement of a witness and anything that the witness knows about a particular case. And the witness need not necessarily be an accused already. Okay? The witness may turn out to be a potential accused going forward, but as on the date of calling a person under 160 CRPC, the person may not be an accused, but may be a potential accused. Okay, that one aspect one needs to keep in mind. A lot of other questions that are arising. First and foremost, many people ask a question whether a person called under section 160 CRPC is going to be arrested or not. The answers are both yes and no, because we have both the kinds of cases in the past wherein some police authorities and some crime investigating authorities have called the individuals under section 160, and during the course of taking their witness, when they found their role as the utmost potential role in the crime, then they have taken them into custody from there onwards. And there are also citations which state that a person who comes for witness generally need not be arrested unless the consequences or the compulsions create such kind of scenario wherein the arrest of the witness is so essential for the case. And then, is it bailable? If the case becomes so, then the question comes, is it bailable? Yes, it's a bailable section. And again, some people in a hurry, when they get section 160 CRPC notices, they tend to go to the courts for quashing the notices. Such kind of approach by the concerned parties approaching the courts may be a premature act, and they may not get relief normally from the courts in terms of quashing the notices under section 160 CRPC, because courts never stop investigations, and notice under section 160 CRPC is a part of investigation. So one cannot go to the court challenging the issuance of notice under section 160 CRPC and then request the court to quash the notice that has been issued. So generally in 99% of cases, the notices issued under section 160 CRPC haven't been quashed. But again, see, since the police call only for taking the witness under section 160 CRPC, and then again the person who receives this notice ignores the notice or doesn't take the notice seriously, then the consequences are going to be very severe. That one needs to know quite well, because there is a punishment for affray. Another way to look at the danger of section 160 CRPC is that as and when the so-called VIPs or politicians tend to get the notice under section 160 CRPC, they tend to exhibit their strength by showcasing their followers or the public, and then sometimes their followers tend to raise slogans against the investigating authorities. Such kind of scenarios are called as affray. Whoever commits an affray shall be punished with imprisonment of either description for a term which may extend to 1 month, or with fine which may extend to 100 rupees, or with both. Some people tend to ask in general that if somebody gets a notice under section 160 CRPC and if he is not going to attend as a witness at the concerned jurisdictional investigating agency's office, then what's going to happen? Though section 160 CRPC provides for officers' power to require attendance of witnesses under the provisions of law, a person is required to attend requisition of the investigating agency. If one decides not to attend without a just and proper cause, the police may apply before the court or issue a non-bailable warrant or arrest the concerned person to procure the attendance of the person to conduct their investigation smoothly in order to obtain the witness statement. That apart, failure to attend the police station or investigating agency's offices on a specific date and time as mentioned under the notice of 160 CRPC without any just cause, or if one intentionally omits to attend, then it amounts to a commission of an offense, namely non-attendance in obedience to an order from a public servant, and it is punishable under section 174 of the IPC. Such offence, when proved, is punishable with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. So, basically, for any person, whoever receives the notice under section 160 of CRPC, the duty that they need to fulfill is to respectfully attend the investigating agency's requirements in terms of their need for information, and provide all that whatever you know about a crime, and help the investigating agencies in conducting their work smoothly, so that there won't be any problem to any person, whoever is called under the section 160 CRPC. If you tend to prejudice yourself, if you tend to think that you are going to be a victim, or you have a feeling that you did a wrong thing and you may be inflicted at any given point of time, then if you tend to avoid, then there is a danger of infliction of section 174 of IPC on you, or even the investigating officers can take action on you on the part of any affray if you create by showcasing big number of people supporting the concerned person who was called for the investigation by the interrogating agencies. So it's always better to cooperate and coordinate with the investigating agencies and help them in tracing out the issues involved in a crime. Then there may not be any problem. But if one resists, then the problem may arise. Thank you very much.